All right, good afternoon. We're back on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. We have a probation violation arraignment in People of the State of Michigan versus Ashton William Moxlow. It's file 23-6743FC. Counsel, you want to state your appearances, please?
Melissa Goodrich, Sheboygan County Prosecutor.
For the record, Ronald Varga appearing on behalf of Mr.
Good morning. Well, good afternoon. And Mr. Moxlow, it's alleged that you're in violation of your probation.
Yes, sir.
Count one alleges that you on or about December 18th consumed alcohol. That would be a technical violation of your probation that would carry a maximum penalty of 15 days in jail. It's also alleged in counts 2 and 3 that you committed non-technical probation violations. Count 2 alleges that on or about December 18th, you were involved in behavior that violated the criminal law in that you were operating a motor vehicle while intoxicated and were arrested in Benzie County for operating while intoxicated. Count 3 alleges that on or about that same date, you were involved in a violation of criminal law in that you were operating a motor vehicle without a driver's license and was arrested in Benzie County for no driver's license. Those are not technical violations, meaning if you are found to be in violation for those reasons, the court could revoke your probation. You are on probation here for attempted child abuse in the second degree, which carries a maximum of 5 years in prison. So if you are found to be in violation for counts 2 or 3, I could revoke your probation and sentence you to that maximum penalty of 5 years in prison. Do you understand the maximum penalties, Mr. Moxlow?
Yes, Your Honor.
Okay, now you have the right to have a hearing on these allegations where they would need to be proven by a preponderance of the evidence. You have the right to the assistance of a lawyer at that hearing. Mr. Varga is here to help you with the arraignment today. If you qualify and ask for a court-appointed counsel, we would certainly do that. Also, you can present evidence in your defense at any probation violation hearing, and you can question any of the witnesses that are presented, although the rules of evidence don't apply except with regard to privilege. Do you understand the rights that you have, Mr. Moxlow?
Yes, Your Honor.
And Mr. Varga, how does he wish to plead?
He's going to plead not guilty, Your Honor, and request a hearing in this matter.
Okay, we'll enter a plea of not guilty as to all 3 violations. We'll set it for a probation violation hearing, and Mr. Varga, is Mr. Moxlow qualified for assigned counsel?
He is qualified, Your Honor, and the case will be assigned to Liz Elliott.
Okay, so we'll take a look here. We could schedule this then for a probation violation hearing. Well, I guess first off, well, we'll set it for a probation violation hearing January 6th at 11 a.m. And Ms. Goodrich, as to any pre-hearing release?
Your Honor, the concern here is that he was not only consuming alcohol, but driving while doing so while on felony probation. So I'd ask that his bond be revoked until the hearing.
Mr. Varga, any input?
Your Honor, we're asking for consideration of at least some type of nominal bond. We prefer a PR bond if the court would consider that. He is employed. He lives in the Frankfurt area. That does cause some problems, obviously, for occasion, but he lives in Frankfurt. Has been relatively, I think this is his first violation of his probation. And he's not a threat to run, or he's not a threat to the general public.
All right, thank you. Well, Mr. Moxlow, you're on probation to me for a serious offense. It was pled down from capital offenses, and your guidelines were a straddle cell, and you didn't receive prison at that time. This was a sexual offense against a minor, and then while you're on probation, you're allegedly out there driving drunk. I'm not sure why on earth that would be happening. Somebody on felony probation, but I think you're on felony probation, alleged to be out there committing more crimes that do affect public safety. I'm going to order you be held without release until further order of the court. So we'll schedule it for January 6th at 11 a.m. And Ms. Goodrich, since that is, it's 15 days from now, so it's roughly within the 14 days required. Maybe reach out to Ms. Elliott whether she wants the contested hearing that date or not, but we'll put it on for the hearing.
Okay, thank you.
Thank you.
All right, because Mr. Moxell, just so you know, for probation violations, you don't have a right to bond like on a new case. You do have the right to have the hearing within 14 days. So I'll do that. Many times the defense wants to postpone it to see what's going on with the case. You and Miss Elliott can talk about that. Okay. All right. In the courtroom and also online. And we're calling the case of People v. Marissa Johnson, file 25-7033 FH. Counsel, please state your appearances.
Melissa Goodrich, Wayne County Prosecutor.
And good morning, Your Honor. James Gilbert here on behalf of Ms. Johnson.
All right, Ms. Johnson, can you see and hear us fine?
Yes, I'm gonna turn my Wi-Fi off really quick to make sure it doesn't cut out because it really is terrible here though. Oh, it's already off. Look at that. There, it won't even do it on me.
All right. All right, well, this is a case that's scheduled for a jury trial in a couple weeks, and the parties have come forward with a plea agreement for an added count 5, possession of methamphetamine, and added count 6, use of fentanyl, with a sentence agreement for no immediate jail. Is that how we're proceeding today, counsel?
Yes.
It is, Your Honor.
And Mr. Gilbert, you consent to the filing of the amended information?
I do, and I have a copy.
All right, Ms. Johnson, would you please raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
You can put your hand down. Are you Marissa Mae Johnson?
yes,
Ms. Johnson, a guilty plea hearing is an important event. It includes the waiver of constitutional rights. So I want you to listen carefully. If you have a question, you just ask me. If you need more time to talk to Mr. Gilbert, you just let us know, okay?
all right,
Now I have to advise you the maximum penalty that you could face on count 5, possession of methamphetamine. It's a felony punishable by a maximum of 10 years in prison and or a $15,000 fine. Count 6, use of fentanyl, is a misdemeanor punishable by 1 year in jail and or a $2,000 fine. Do you understand the maximum penalty for those crimes?
I do.
Are you on probation or parole anywhere?
No,
And were you on bond for any other cases at the time of this incident?
no, no, I had to think about that.
Okay. And did you read the advice of rights form that Mr. Gilbert sent over to you?
Yes,
You have any questions for me or Mr. Gilbert about any of those rights?
I do not.
Okay, I want to remind you of what some of those rights include. You have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proves your guilt beyond a reasonable doubt. You have the right to have the witnesses against you appear and to question them. You have the right to present witnesses in your own defense and have me order them to show up. You have the right to testify in your own defense or to remain silent and not have your silence used against you. Do you understand those rights?
Yes,
Do you wish to give up those rights and enter a guilty plea today?
I do.
If I accept that plea, you give up any claim that it was caused by threats or any promises outside the terms of the plea agreement. Do you understand that?
I do.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission. You would do that by filing an application, but the types of issues that you could raise on an appeal after pleading guilty are very limited. Do you understand that?
I do.
All right, the plea agreement provides an exchange for your plea to the charges I outlined for you. The other charges will be dismissed, and there is a sentence agreement for no immediate jail. Do you understand the terms of that plea agreement?
I do.
So that means you could be placed on probation, and if you violate probation, you could get jail. But at the original sentencing, there's an agreement that you would not go to jail. Do you understand that?
Yes,
All right, now that sentence agreement is not binding on me, meaning I don't have to follow it. But if I didn't want to follow it, you'd be allowed to withdraw your plea, not having received what you bargained for. Do you understand that?
yes,
There's a very important exception to that rule. Here's what it is. If you engage in any misconduct between now and the time of the sentencing, by either not showing up for court, absconding on your bond, violating your bond, or committing new crimes, That type of misconduct would cause you to lose your right to withdraw the plea, even if I did not follow the sentence agreement. Do you understand that?
Yes.
Has anybody promised you anything other than the terms of the plea agreement?
No.
Has anybody threatened you to make you plead guilty?
No.
Is it your own free choice to do so?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 5 of possession of methamphetamine?
Guilty.
How do you wish to plead to the charge in count 6 of use of fentanyl?
Guilty.
So back on March, in early and mid-March of 2024, were you in Sheboygan County?
Yes.
Were you, while you were in Sheboygan County, in possession of the controlled substance methamphetamine?
Yes.
Did you know that you were in possession of that substance?
Yes.
And did you have any lawful authority in the state of Michigan to possess that substance?
I did not.
Mr. Gilbert, is the use going to be a use or a possession for the factual basis?
It's probably going to be a possession.
Okay. And so, Ms. Johnson, back in that same time frame while you were in Sheboygan, were you in possession of the controlled substance fentanyl?
Yes.
And did you know that you were in possession of that substance?
Yes.
Do you have any lawful authority in the state of Michigan to possess that substance?
No.
And based upon that, I would find a factual basis for the lesser charge of a use. Mr. Gilbert, are you satisfied with the factual basis?
I am, thank you.
Ms. Goodrich?
Yes.
Mr. Gilbert, are you aware of any other promises to extra inducements?
I am not.
And in your judgment, have I complied with the requirements of MCR 6.302?
I believe you have, thank you.
Ms. Goodrich, do you agree as to both questions?
Yes.
And Ms. Johnson, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of those offenses. So I hereby accept your plea. We'll cancel the jury trial, and I'll schedule sentencing for February 3rd at 2:10 in the afternoon. Now you'll have to contact the probation department and cooperate with a pre-sentence interview so that they can write a pre-sentence report for me with recommendations about what your probation should look like. You have to cooperate with that process, okay? And you have to
Okay.
be in person for the sentencing. I also want to bring to your attention, I did talk with the attorneys before we went on the record. Last time you were in court, I talked to you about the not testing, and we've got a pending contempt. And I was informed that you were doing some drug testing through DHS. Is that correct?
Yes.
Okay, we still don't have copies of those, and I still show that you are calling every day and then not testing when you're required to test for us. So here's what I'm going to tell you about that. I told your lawyer before we went on the record, my intention today was to cancel your bond and tell you to report to jail today and sit until February. He prevailed upon me to not do that. What we're going to do is this. You must get to Mr. Gilbert immediately all the copies of the DHS tests, because we don't have them.
I contacted my caseworker actually via Facebook because she's on vacation right now to see if she could get me those so I can get them over there.
Okay. The other thing you need to
I
know is
disclosed that with
this.
Mr. Gilbert prior to this.
The other thing you need to know is this. I don't care if you're testing for DHS, because now this is going on long enough and I'm not seeing copies of it. If you called today and you have to test, or you call tomorrow and you have to test, you are testing for me as well as DHS. DHS tests do not count for you going forward. You understand me?
Okay.
And that means this: you're sitting on a no jail recommendation or agreement. If you call tomorrow and you're supposed to test and you don't test for us, I will sign a warrant for your arrest and you will sit in jail until February. You understand?
Okay. Yes, Your Honor.
All right. Anything else from the people?
No, Your Honor.
From the defense?
No, Your Honor, thank you.
Okay, we'll see you then.
All right. Thank you.
All right. Good morning, everyone. Are we on the record there in the district courtroom in
On the
Prescott
record.
County?
Yes, we are.
Okay. All right. Good morning, folks. We are on the record in the 53rd Circuit Court for the County of Presqu'île. We are providing public access to this hearing in the 89th District Courtroom in Presque Isle County and also online. The hearing is being conducted, it's being clerked in the district courtroom. I'm attending via Zoom from the circuit courtroom in Sheboygan. And we have counsel for the prosecution and the defense appearing by Zoom video. We're here for a status conference in the case of the people of the state of Michigan versus Tommy Lee Carlson. It's a 1991 case. It's number 91269 FC. Counsel, you want to state your appearances for the record, please?
Good morning, Your Honor. Zachary McLennan for the people.
Good morning, Your Honor. Tina Olson from the State Appellate Defender Office on behalf of Mr. Carlson.
Okay, good morning. I'm sorry, we're getting an echo, I think, in the district courtroom somehow. I don't know, but one housekeeping thing, just so that people don't get confused with filings. This obviously is an older case. It was originally numbered 91-1269 FC. Presque Isle County was in the 26th Circuit Court in 1991 with Circuit Court realignments. I think it was 2003, was it, when Presque Isle County joined the 53rd Circuit with Sheboygan County. And that required, because the numbering systems, there would have already been a case with that number. So the Presque Isle County cases all have a 9 in front of them. So we're treating this case now, Ms. Olson and Mr. McLennan, as number 91. It's a 1991-91269. All right, and then we set this for status conference. This is a result of the Michigan Supreme Court's opinion in Zarnecki and Taylor, extending the juvenile lifer rules for anybody convicted of first-degree murder when they were less than 21 years of age at the time of the offense. The prosecuting attorney has fulfilled the statutory duty to advise us of how many of those such cases would be in Presque Isle County. And there is one, this one. And because the Supreme Court's decision applies retroactively, we need to set Mr. Carlson's case for a resentencing. And Ms. Olson, I'm operating under the memoranda that SATO had sent out to courts, sort of by analogy, applying MCL 769.25A for the timeline, which would give the prosecution a deadline of January 5th for whether they will be filing a motion for resentencing for life without parole. Or whether they'll concede to a term of year sentence. So I guess the first question is where we're at on that decision, because that probably affects the work. It probably affects to some degree the mitigation materials that SATO would need to do. Is that right, Ms. Olson?
Yes, Your Honor. That's going to inform how much time the whole process will take.
Okay. So, Mr. McLennan, I guess I wanted to set a status conference before that deadline just to find out where you're at in that process. If you agree that that's what your deadline is, and if you've made a decision or if you know what you're doing yet.
Yes, Your Honor, I do agree January 5th would be the deadline for filing that motion. And we are intending to file that motion and working on it right now.
Okay. So with that then, Ms. Olson, when we receive that motion, I guess I'll hear input from you on what you envision for a timeline. When that motion is filed, then we'll have to conduct the full Miller hearing. So when the motion is filed, should we schedule it for should I set this for a status conference in February or something? Or what do you think is our best next step?
Yes, Your Honor. I would say, knowing that they will be filing a motion, perhaps even setting a scheduling conference for March would be a time when we might be able to record a good idea of how long the investigation is going to take. We were just fairly recently appointed. We don't appear to have complete MDOC records. I note that Mr. Carlson came here from out of state. So I think a scheduling or status in March, we'd have a much better idea of what we're looking at in terms of time frame for investigation and mitigation.
Okay. Mr. Clennon, any objection to that?
No objection, Your Honor.
Right, so what we'll do then is we'll await the prosecutor's filing of that motion by the January 5th deadline. We'll set this for a continued status conference on Monday, March 2nd at 9 a.m. And I will allow appearances by Zoom. And Ms. Olson, just let us know at any point if you want Mr. Carlson to appear by Zoom. You can just let the prosecutor's office know, and they can prepare a video writ so that we have DOC zoom him in. And then at that point, we can see how much time you need to complete your investigative work and how many days we need to schedule for a hearing. I imagine it'd probably be a couple days at least.
Yes, Your Honor. Generally, the hearings do take 2 to 5 days, honestly, but we'll have a much better idea in the future. So I appreciate that.
Okay. All right. Anything else that we need to accomplish today from the people's perspective, Mr. McLennan?
Nothing I can think of, Your Honor.
Ms. Olson, anything from the defense?
No, Your Honor. Thank you.
Okay, thank you. We'll next call the case. As I said, March 2nd, 9 a.m. and Zoom appearances are fine. All right. Have a good day.
Thank you.